Good. Okay. Good afternoon, and thank you for joining. It's my pleasure to welcome Dominic Russell from Coleman Greig. Together, we're going to have a chat about employee departure and managing the risks, of that. So, welcome to everybody, both who could be here in person and to those online. We can make some of the session slides details available subsequently on request if need be. Employee risk generally, there's two parts as those attending would no doubt understand, and that's both the legal side and also the evidentiary and the investigative side of what can happen and the impacts on an organisation when employees, particularly those who have access to key data assets or intellectual property assets, leave an organisation. It's not always malicious, so some people tend to jump to that, but that's not always the case. It sometimes can be inadvertent, but the risks are present nonetheless. So for our part, Dominic's obviously on the legal side and provides advice in relation to that. He's a workplace specialist. For my part, it's more around the electronic data and the footprint that's left behind, and how what is and isn't possible, and what we can do to bolster the legal case if that's the action that needs to be taken by the employer to either recover the assets or indeed just minimise the risk. Dominic, over to you.
Thank you, Stan. So we want to really just talk about the employment, firstly the relationship itself, and look at some risk mitigation strategies that companies can employ during the relationship to ensure that when the inevitable employee relationship breakup occurs, that a company is best placed to either take that action if it's necessary, or at least just ensure that, that there has been no damage done, even where the employee isn't a risk. So departing employees can pose a very significant risk because they have that capacity to form relationships with the client base, and they have widespread access to commercially sensitive information, and more importantly, they've received training on how best to exploit it as part of their job. So businesses do need to plan for that breakup from day one. So I just wanted to talk firstly about just some key high-risk employee types. Now, apart from the first example, the key person, these are mostly just from my own experience as an employment lawyer and litigator. The first type of risk person that I see a lot of is the key person. And this is a person who, not necessarily by design, just by circumstance, finds themselves in a position where they have become responsible for too many things, and a company can struggle to operate in their absence. These sorts of people tend to find themselves in that position when, for example, inadequate workflow systems and automation result in functions needing to be done manually, insufficient cross-skilling, insufficient training, and the company is just quite happy to be reliant on them alone to perform that function.
Yeah, so often they're the people, when you've seen a company grow, so they'll, particularly in the small to medium business arena, the company will start with key individuals, and then they will grow with the organisation over time, and those people know the company backwards, they know the operations backwards, they have access to everything from a systems point of view, and not necessarily by design, but as Dominic mentioned, they become a critical person because they just know how things work. And when they leave, that's when you really understand how much they were critical to the day-to-day operations of the business. Not necessarily by design, but certainly risky, just the same.
So the next high-risk type of employee that I see a lot of is the disgruntled employee. This is a person who will have expressed some form of workplace grievance, formally or informally. Their motivations, I should find, are emotional rather than financial. They can sometimes feel that they're being set upon, and so they'll seek to gather evidence by themselves furtively. They're disruptive to other employees, often trying to get people on their side. They can issue threats of going public and engage in acts of sabotage. the general position with disgruntled employees, if at all possible, is to try and minimise the danger that they pose to the workspace and environment. And if they are a departing employee, workplaces should be looking at strategies for removing them from that environment very carefully, and certainly getting some legal advice on how best to do that. On a matter that Stan and I were recently involved in, we had a disgruntled employee who did actually engage in acts of sabotage and attempted to, how would you say, disrupt a couple of key pieces of infrastructure, and it unfortunately resulted in the police being called and going out to his house and seizing assets. And
he claimed it was mischievous as opposed to malicious.
Malicious.
But the police got involved, so that was obviously not the case.
Yeah. So it's also the disgruntled employee that's most likely to become a whistleblower, and that again poses its own set of risks. I don't know if you wish to comment about that.
Yeah, so the whistleblower legislation provides for some confidentiality protections and other things that the organisations have to abide by. So with that process comes some requirements that you then have to meet if they are claiming whistleblower status. So you need to put or have a process in place around that, and sometimes the technology side of things can provide the evidence to support or counter that argument, which can then go back to the legal side. But they can claim it spuriously. They'll see it as legitimate, but given they're disgruntled, that is not always the case.
The next is, I think, possibly the most dangerous of all employee types. This is the one I call the accumulator. They are most likely to be a long-standing, highly trusted person, often a very key person in an organisation. They're always the one who put their hand up to take on any job, that's no matter how big or small. And over time, they just slowly accrue greater access to privileges and information systems, and sometimes even get approval to act contrary to company policies. A couple of examples of that I've seen recently include storing information in a location where the rest of the company don't have access to it, or getting permission to sign off on transactions without going through ordinary channels. The accumulator, a couple of, I suppose, hallmarks of this person. They can be reluctant to delegate tasks. They're prone to being a micromanager. They'll often work long, irregular hours, often alone and unsupervised. They rarely take leave. They can accrue a very significant leave balance over time. They will have data stored in strange locations, as I've noted there. And the risk is that an accumulator, who is also somebody who might be a fraud risk or a theft risk, is that they engineer their environment to suit their modus operandi, and use those accumulated powers to mask fraud. Now, certainly without wishing to make any accusations, an example in recent public life of an accumulator who may or may not have engaged in any nefarious conduct would have all seen is ScoMo with his multiple portfolios. He may not have needed to access it, but he's wanted it and he's collected that power to himself. That's a very clear indicator of an accumulator type.
Despite being inside the rules at the time. And there's a couple of things, a couple of examples. So one that comes to mind was a guy that worked in various roles, and because the IT controls weren't appropriate, so as he moved from one role to the other, he accumulated more access, but the old ones weren't removed. And in the end, he ran an application which he thought he was running in a sandbox, which is like a safe environment. What he didn't realize was that he was running it in a live environment, and he caused all the trains in the city to grind to a halt. And that meant that they didn't meet government regulatory guidelines for being on time, et cetera, et cetera. So he didn't do it maliciously, but he did it unintentionally because he had accumulated all these privileges, but didn't have the knowledge, the prerequisite knowledge that went with that to understand what it was that he was doing. So non-malicious but significant impact and issues on the other side that the organisation couldn't report to the government, let alone tell them how late the trains were because everything just shut down. That's the way it was. So those sorts of things can happen, and they are obviously significant risks, whether whether malicious or not. So if you add a malicious lens to that, it can make it so much worse.
And of course, another high risk type is an employee who's going to leave to a competitor or start their own business. They can be a bit secretive about where they're going. In my experience, they should be treated with extra caution during the notice period. Sometimes these people are not malicious. They're not going to steal your customers, and they may actually be a valuable contact down the track. But they also might start trying to access business records that they've got no reason to see. Common targets would include client and supplier lists, sales data, price lists, quotes, etc., designs and templates. One of the things businesses need to be looking for is that they can be liable to try and find ways to send and transmit data, particularly commercially sensitive data, from a company source to an external source outside the control of the company, such as by email, copy into external storage, cloud storage services and the like. And also they can start working in their future employers' interests instead of the company's interests, and particularly diverting work away, making offers, say, such as, I can get you a better deal in 2 weeks' time if you just hold on. That sort of thing is very common. But as far as finding ways to send commercially sensitive documents, maybe Stan, you can comment on that.
Yeah, look, a particular one that comes to mind, a guy was leading an organisation and tried a number of steps. So, you have organisations typically have things like USB controls. You can't write to that, so that wasn't an option. He then tried to upload the data to a cloud-based shared platform, kind of like a OneDrive, a personal OneDrive, but the volume of data that he was trying to copy was so large that it was going to take forever, and it flagged with the IT system. So up pops the red flag to say, hey, this person's trying to do that. It was going to take hours, so he abandoned that, and then he started emailing some stuff to a personal address, which of course flagged again. So it's important to understand that when they're acting in this way, there's a whole bunch of red flags that IT can pick up, and they are all part of the evidentiary trail. So in addition to being able to identify them proactively, you also want to be able to collect that information, because it becomes really valuable in terms of evidence and mitigating risk subsequently.
Yeah, and that's a good segue into the next section, risk management. Record keeping is an absolutely vital part of the evidentiary trail, which is, I suppose that's a large part of my job is dealing with it when it goes wrong. But to start with, from day one, getting a signed copy of the contract of employment is very important. It's the best example, the best evidence you have of the agreement that was reached between the employee and the company as to what what they've agreed to do. It's also the only way in which you could possibly enforce post-employment restraints of trade. If you want to prove that they've agreed to be bound by it, you need evidence, and a signed contract is important. There's a case here I've noted, Argo and Divine Real Estate. This was a case which ultimately the real estate company won, except that in the case of one of the two employees in question, the restraints that were attempted to be enforced, the court dismissed it on the basis that the company had failed to keep a signed copy of the contract, and they had no way of proving that the employee had agreed to it. So that's just an example of where it can go wrong by a simple error of admin. So some recent examples just from my own experience. One company issues a contract to an employee via email. This is extremely common. The employee just turns up to work on the first day. The company don't have any follow-up process in place just to make sure that they get a signed copy and keep it. Another is where the company is attempting to enforce the post-employment restraints against an employee who's commenced with the company. When the employee started with the company, responsibility for storing employment contracts had been given to somebody who's now left, and now nobody knows where they've kept it. It's just a very simple, basic administrative hygiene that all companies can get on top of, but it's just lacks processes that can result in this sort of thing occurring.
And when when you think of it, this is part of this, particularly again with smaller companies that are growing rapidly. If you think about the overlay to what was mentioned previously about key employees, so someone who's grown up and developed with the company at the same time, so now they're a key employee, so they're high risk, but they've got no signed contract, or we didn't have it back then because we all trust each other and we're a family business and we've grown up and we've expanded exponentially, and now we're doing really well and we've broken on the international stage and whatever else, and now that person is trying to leave. So then you've got the compounded problem of no documentation, and they're a key employee, or they've got key access to data or intellectual property. And a lot of the issues around this is the idea that we grew up as a small group. We started this company together, and it's grown, and we all trust each other. So to start putting controls around this in place will give the bad impression that I don't trust my staff because they've been with me forever. And I've lost track of the number of times that we've had somebody who's been with the company for 20 years and they're a trusted person, and then they've committed a fraud. And the owner is devastated, but they've never put the controls in place because they had this concern that that it would make the employees think they didn't trust them, when in actual fact doing this protects both the company and the employees. So they've got to, it's all about the messaging. They've got to turn that around and have the employees understand that these issues are being addressed to protect everybody, including the company that we all grew up with and love, for those who stay. Because invariably, the person who commits fraud and leaves, you're not going to worry too much about them. You want to protect the ones who remain behind because they're so much more part of the company. And invariably, when we see something like a fraud, for example, a significant one, if in a small team, then normally you'll have the fraudster who's suddenly outed because they've been found out, and 9 times out of 10 you'll have 2 or 3 others in the team will depart the company not long after, not because they've been involved in the fraud, no way at all, but the sense of betrayal that their friend or colleague that they've worked closely with generally over a long period of time has been misusing them all these years. So it might be as simple as, hey, Dom, I'm having trouble accessing the printer. Can you log in for me? I just need to print some stuff. And you say, yeah, sure, I'm heading off for lunch. I'll just log in, do what you want on my computer, because we're friends, right? We've been colleagues for 15 years or whatever it may be. And then that person gets in and starts, approving things or whatever it may be. So it's a protection mechanism for the staff as well as the organization. But unfortunately, a lot of the time it's seen by employers as counter that the staff will dislike them because they're putting these measures in place. But it should be a positive thing. Not a negative.
Yeah, that's right. Workplace surveillance policies. This is another very important tool that all companies, I think, all around the country really do need to have, even in states where there are no mandatory rules. Because most businesses do carry out some form of workplace surveillance, whether they think of it in those terms or not. And it could just be CCTV cameras just monitoring the perimeter or the front footpath. Other types include vehicle tracking, monitoring email and internet usage, electronic time recording, Bundy clocks and the like are all a form of monitoring, logging employee activity, and it's a form of surveillance, and they all create logs which can all be used as evidence somewhere down the line.
Yeah, it's workplace surveillance can be interpreted as a bit of a dirty word. We're monitoring our stuff, particularly in the current environment where there's a lot of people working from home, and how dare you monitor me in my own home, and how much monitoring is going on. But it's happening anyway. So it's a matter of communication and transparency. Let them know what's being monitored so that it sets the expectations up front. Then they're aware of it. And I'm not talking about turning on the camera to see what they're doing at home, but it's about being aware of what information is being collected about staff activities. And again, it's a protection mechanism for them, so that if someone says that they're doing the wrong thing, then monitoring will actually protect them and saying, well, no, they're not. They're actually doing what's expected of them. Sure, they might be doing internet banking at lunchtime. That's okay under a fair use policy. Or they might be looking at news.com, and that's all right. It's not that some image that comes up or something else is inappropriate. They're not behaving inappropriate. Their activity is actually tracked and it's defensible. So it's really about the comms on this one.
Yes, that's very important. In New South Wales and ACT, though, in particular, workplace surveillance is prohibited unless there is a policy in place. There's legislation which governs what that needs to look like. But they're both very similar pieces of legislation, but they require that the nature, method, and period of surveillance being carried out is explained in writing. And the policy also needs to explain the purpose for which the surveillance might be used. So if you say to staff that we're going to monitor your internet activity so we can work out how to market ourselves and limit it at that, you might not then be able to use that same internet activity to then prosecute them for a breach of some other policy or just not doing their job.
It's really important.
So you need to actually get it right and make sure that the language of the policy clearly explains what surveillance is being carried out, how long it's going to be carried out for, i.e. is it permanent, is it temporary, and how is the information going to be used. In other states and territories outside of New South Wales and ACT, there are Privacy Act provisions which do apply. In some cases, there is an employee exemption, which companies can rely on when it comes to personal information about employees, so long as it's related to their job. So companies that acquire information about their employees that's not related to their job, that falls, that's protected by the Privacy Act.
Yeah, and you need to be cautious because there's particularly with IT evidence, so the use of a computer in their day-to-day activity, by normal operations, and not part of surveillance, but a normal computer's operation collects a raft of information about what you as a user do. That can be potentially used as evidence, potentially. But the organisations need to understand from a risk perspective what that means, because we often get asked that, for example, we might look at somebody's computer and we can identify what their user ID and password is to their personal email account because they've tried to upload some IP. So can we access that email account? The answer is no, but you're getting into a legal area. So even things like recently opened files and linked files and all those other bits and pieces, which will show you what that looks like shortly. But when the computer is routinely collecting that evidence, you've got to make sure you're on safe grounds as to whether you can then capture and interpret that in terms of an employee action or employer action, I should say, versus does it fall under surveillance and does our policy cover this process? So you need to get the policy right rather than just launch straight into, well, the forensic technology guy like Stan says that we can gather all this evidence and prove this has been happening, but if your policy and structure isn't right in the first place, you might be excluded from using some of that. So you need to consider that.
Another issue relevant certainly to people outside of New South Wales and ACT, they might think that they can get away with not having a policy, but if you want to rely on workplace surveillance evidence, for example, in a dismissal, and you don't have a proper policy that's been explained to the employee, you might find yourself on the receiving end of an unfair dismissal application for not having a proper, clear, transparent process and procedure in place anyway. So it doesn't really matter which way you look at it, it's still prudent to have one, and being proactive about that from the outset is very important. In New South Wales specifically, the notice of the policy needs to be given 2 weeks before it can even be implemented. So of course, unless the employee comes into a workplace which already has one, but so you can't just discover a problem and go, oh, quick, we better get a policy, let's put it in place and then catch them, because that won't work, it won't fly. So you do need to have that in place from the outset.
Okay, yeah, so in terms of investigations, there's a raft of evidence that can be, and that can be collected, and most people will default straight to the person's computer. And fair enough, there's a lot of evidence that can be gained from a person's laptop or desktop computer or their activity generally on the network. But there's also a whole bunch of other activities, so swipe card access to floors and buildings and other bits and pieces that can be accessed and then combined to form a picture of what they're doing. The collection process in terms of making that admissible in court is very specific, because it has to be a proper forensic process that's defensible and repeatable, because the courts are relying on the individual who's appointed the expert to be able to interpret that appropriately. So you need to get it right, particularly where there's different interpretations of the same circumstances, i.e. a person goes to a website and let's say inappropriate material is displayed, but did they go there for that purpose, or was that because of some other automated action on the system? And there's an expert opinion sought by the court in relation to that.
Yeah.
So you want to be on the right side.
And the other side, of course, is under rules of evidence. Anything that's been obtained unlawfully, i.e. in breach of a policy or in breach of the Privacy Act, may be inadmissible. So if the silver bullet piece of evidence that you've got has been obtained via some unlawful process, you might go to court with the best case in the world, but are unable to prosecute it because the evidence is going to be thrown out. Now, in this case, Secure Logic, the employer had used a piece of key logging software. So that's something where it just monitors keystrokes, and attempted or wanted to use that as evidence in some proceedings against a couple of employees. There was no policy in place, or not an adequate policy. They did have a policy, but it didn't satisfy the requirement of having given notice of the policy to the employees. And in the end, they weren't allowed to rely on that evidence of the key logging software. They did get the evidence in via another way, and the employees in that case were silly enough, I think, to break into their employer's premises to try and destroy evidence, which didn't help them in the long run. So Secure Logic, I think, got the outcome they wanted, just not in the way that they wanted. And they were lucky, and it probably cost them a bit more because they had to work a bit harder to get the evidence in via a back door. The next policy risk mitigation issue that I want to talk about is bring your own electronic devices. Employees will use whatever device they can get their hands on to do their job, whether it's something the company has given them or it's something that they own at home. They will just go to their trusted process unless they're given the tools to do it and instruction and training. Now, allowing staff to use their own devices, it can save a company money, but that's about it. It can create risks. Staff access and send documents and information because they'll retain copies outside the control of the company. There's no way to control and monitor what the applications are that are being used on their personal devices. So some apps might interact in a way which the company doesn't understand. They might access information and transmit it in ways that we can only speculate. So that increases the risk of data exfiltration. Staff can also take their device when they leave, and that includes the documents that are on it. The staff that use personal phones will have a ready-made client list in their pocket when they walk out the door. Yeah. Company-issued devices will cost money. You can't avoid that, but all of those risks will be averted. They can be configured to control access to company network and mail server, so under an enterprise management system. Companies can also ensure that they have up-to-date standardized applications that are going to work together with each other properly. They can be monitored remotely to identify suspicious activity. So that's a workplace surveillance issue, which you cannot police on a phone. You can't necessarily install bugging software on employees' private phones and computers, but you can certainly install various different types of tracking and monitoring tools on their devices if they belong to the company. And most importantly, they belong to the company. So when the employee leaves, the employee has to hand them back. So companies that issue devices to employees should maintain also an asset register. This is surprisingly something that most companies don't do. But when the question I ask often to a client is, okay, what devices has this person been given? And they say, oh, I think he's got a phone, or you might have had a laptop. Have you got an asset register? And they say, what's that? And it's really just a proper log of what devices they've been given by serial number, by make, model type, when they were given it, and how many of it. And also peripherals such as bags and accessories. You'd be surprised at just how much value there is in the material given to employees that's often not handed back, and how disruptive it can be when a company, particularly the IT staff, are running around trying to find a bag and a charger for for the right type of laptop. So yes, maintain the asset register, because that's also a very important tool, and you might need to submit that register to court if you want to prove that the employee has run off with a piece of equipment.
Okay, so generally in terms of IT proactive controls, and it is about being proactive. So normally traditional IT security measures will include things like backups, critical data accounting systems, and that's all fair enough and appropriate. Extending that to personally identifiable information and indeed critical information assets, so intellectual property of the organisation, is important, and that often backups are treated as just a kind of a standard process that happens in order to restart if we have a system failure or a cyber attack or whatever else. But the extent to which it goes in terms of the preservation, particularly of key assets, of information assets of the organisation, is kind of varied in terms of that approach. So personally identifiable information, because of the privacy requirements for the and the implications of the company that collects that information and why, and also intellectual property from a risk and preservation aspect. We've seen intellectual property devalue a company. One instance comes to mind where a company A was going to buy company B. It was valued at about 20 million. It was a digital online entity, and the entire value of the organisation was in a database. But that asset had been copied to another storage facility by one of the staff, not maliciously. They were working on it. The staff member, an IT guru, subsequently left the organisation, but left the copy, which during a subsequent cyber breach was exposed to the world. So that in the litigation that followed, the cyber breach was discovered as part of the due diligence process, including the fact that this database had been exposed to the world. So that reduced, in the litigation argument, that reduced the company value from 20 million to 0. And then there was a bun fight as to, because the buyer then wanted to renege on the contract, and the seller was then saying, no, you've signed an agreement, you need to proceed. And they had an argument as to what the value of the company really was, because the key information assets had been exposed. Easily resolved with a bit of proactive thinking. So, file access management and who has access to what and when, who has access to what you need to have access. And then if you don't need it because your role changes, like the accumulator we talked before, that access needs to be revoked. It's a simple process, but it's one that's often overlooked. Least privileges is the same thing. You have access to everything you need to, no more, no less. Often we see particularly senior executives will want access to everything. I'm a CEO or a CFO, and therefore I should be able to see everything. Well, that's not true. The fact is that whatever their role dictates they should have access to, they should have access to. Anything outside of that, they don't need, and that reduces the risk. It's not an issue against them personally, it's more an issue of it reduces risk for the organisation and risk for that employee. Because if a CFO has access to everything, and let's say there's a cyber breach and his account or her account is breached, then the baddie has access to everything. So, there's been a number of instances where the entire organisation shut down because people don't set up these tiered controls. So it prevents that accumulation, like the train thing that I mentioned before. It prevents that sort of activity flowing through. So it's purely a proactive measure to mitigate risk. It's nothing against individual employees, and certainly shouldn't be taken that way. Access logging, or audit logging, as we often refer it, that's a really important one, and it's something that's not retained very often. Often we find that audit logging is either disabled because it's believed or perceived that takes up too much space, or they roll it over far too regularly, a week, and then you need a month's worth or 2 months worth of data when you discover something's wrong and it's already gone. So you need to have a think about these things and how that information is captured and stored, because it could be the difference between a win and a loss in a court case subsequently should things go wrong. Ultimately, ounce of prevention, pound of cure. And as much as we're very busy, forensic processes to come in and resolve an issue afterwards, it's an expensive countermeasure to something that would have been far simpler to proactively address in the first place.
On the file access management, case that I was involved in a while ago now, it was a very sad, traumatic one, where a lady had made a sexual abuse complaint about her manager. The company did all of the right things in trying to investigate it and deal with it. The board deputised one of its members to act as a liaison with a third-party investigator who'd been engaged, and in an attempt to ensure that the actual perpetrator didn't see any of the correspondence, what happened was the third-party investigator emailed the finished report to that board member's private email account, and she opened it on her phone as a report, and it synchronized automatically without her knowledge to her iCloud account. And separately, being the nice, kind mother that she was, she had also paid for her daughter's phone, and it was linked to the same account. So when the daughter read it, had no idea what it was, and forwarded it to a friend on the basis that, oh, this is gross, it got out and caused a lot of damage to the company. There were lawyers acting for absolutely everyone involved there. I had the unfortunate job of assisting the board in trying to work out what went wrong. I was thankfully not on the receiving end of the proceedings from the employee whose personal information had been outed. But that was a very difficult matter, and all because a simple setting on an iPhone had been enabled.
Unintended consequence.
Unintended consequence. So moving on to the notice period. So obviously the relationship does come to an end eventually. Whether they resign or terminate it, it's the risky time to manage. Now, all of the risk management processes that the companies hopefully put in place will assist them through this. Now, the first thing to note is departing employees, no matter how nice they are, their focus is onwards. They're not worrying about today. They're worrying about where they're going next. And so just as a matter of course, they're not really interested in looking after their employer's interests. It's also the most likely time that they're going to steal data, to steal client lists, to steal supplier lists, price lists, and also try and destroy evidence of any misconduct, just to sort of wipe the slate clean, so to speak. So it's very important to manage that transition process very carefully. Some simple risk mitigation steps. One is to consider whether or not you have the employee serve their notice period in the office, send them home, or even offer them an early release, depending on whether they might be going to a competitor or not. Another one is to actually prepare a termination checklist. This is a very critical thing to do. That list needs to include steps such as reviewing what workload they've got, making sure that critical dates, completion of tasks. That's something that most companies do. Identifying services and systems that they use in order to manage the removal of access to those systems and the transfer of administration privileges. That is something that most companies don't do. In the matter I mentioned, I worked on with Stan recently, we found that an employee who had left 6 years earlier still owned the company's domain.
Website.
The website, their actual domain for the website, and it was still registered in his name. That's a process that would have identified that 6 years earlier. Also, the return of all company property. Hopefully, if they've got that asset register, they can just quickly go to that to know what they need to be collecting, but that should just be itemized on a checklist. Another risk mitigation step is preparing a letter that clearly communicates expectations and the last date they're required to work, specific tasks expected to complete, property to be returned, and it's also the best time to notify them of any post-employment obligations such as contractual restraints if they apply.
High risk.
High risk.
Yeah. So when we're talking about high risk people leaving, so these are the ones that either may pose a risk because of if they're disgruntled or whatever, but they may be high risk purely because, as I mentioned earlier, they know how the business works. So they have access to a lot of information. They know a lot of people. They know how the business was built, and particularly if they're going to a competitor or starting their own business, there's a lot of risk issues that go with them. there's a couple of key steps, and this is around preserving evidence as a proactive measure. It's not necessarily that you're going to take litigation action, but if you preserve this, it puts you in a much better position if you then have to subsequently seek legal advice. So the standard process for emails, for example, when you delete emails, normally there's a retention period. Even though you empty the bin, it's held for a little while and then it's destroyed. You can extend that, and you can extend that considerably or indefinitely if need be. Retaining activity, evidentiary log files, so retaining evidence of what the user's up to. Transfer activity, again, retaining the logs of that. So what activity did the person do? So if 2 months, 3 months after they've departed, they suddenly pop up with starting a new business in direct competition, and some of their templates or widgets, whatever their designs, are remarkably similar, all of which we've seen before, then you can go back and have a look at, did they copy things? Did they do this? Did they do that? Portable devices are often overlooked. Sometimes they, companies will prevent writing, or they'll allow writing to an encrypted device, which is fine, but if you've got the password, it's easy to access it. And Dominic mentioned a asset register before, and often people think about phones and laptops and computers and whatever else, but things like the little USB drive, they kind of forget about. This is not important, it's cheap. It holds, a few gig of data. Do we copy it on the asset register? It's not worth much, but absolutely you should. And again, we'll show you that shortly, what that looks like, but they are critical in terms of, they might be, if it's encrypted, it might be an allowable thing to store data on. Because it's encrypted, therefore you're allowed to write to it as opposed to not. Proactive activity monitoring, do we enable that to keep an eye on what's happening with these high-risk employees prior to them walking out the door? It's purely preservation at this stage. It's not saying that you're going to take action, but it's a proactive measure. So if something happens down the track, you don't then have to go and hunt out all this stuff, some of which may be gone or never captured in the first place. So there are a few easy, simple things that you can implement as soon as a high-risk employee or the departure of a high-risk employee is identified, particularly if they're disgruntled as well as a high-risk employee, then that elevates again. So you should do that as soon as possible, but also, as Dominic noted earlier, in the time immediately prior to the departure, that's when this key activity, as I mentioned before, someone trying to upload stuff, copy it to USB, email it, they're trying to get it out any way they can, and that activity will be logged by the system. It's up to the company to retain those logs and not have them overwritten. So if they take the proactive step, it's easy to pull them out and say, well, here's the evidence of wrongdoing, and now we can take action, as opposed to, well, we did have evidence, but after 3 weeks it was overwritten, so now we've got nothing. And then you've got to go and try and trawl systems and piece together activity that happened.
Yeah, and the only other thing to add is it's also very important to make sure you take some steps to think about what are the actual critical pieces of business information, what in the hands of a competitor is going to damage my business. And that could just be intellectual property templates. It could be your client lists, your list of current projects, your business development plans, whatever that might be. It's a good thing to know what that is, because certainly if you ever have to go to a court and say this employee poses an enormous risk, they're going to ask why. And if you say, oh, well, they've got my client list, and they're going, and I mean, I could look up your clients in a phone book, how is it valuable? And you have to be able to explain why it's valuable. And that's something that companies need to do, certainly before the employee leaves. Termination day. I would always recommend that companies have an exit interview. Just produce all of these dot points. The exit interview is very important to have. That face-to-face meeting with them not only keeps it real, but it also provides the most perfect opportunity to actually take physical possession of things like phones and laptops, obtaining copies of their passwords and PIN codes to those devices, rather than waiting for them to send something in the post or ring. And it ensures that termination letters, for example, have been given and read. That's the one which would set out the expectations around post-employment obligations. You can potentially obtain a declaration from them, a promise in writing that they have in fact returned everything or declared everything in their possession that belongs to the company. That's a very critical piece of evidence if you can get it. A lot of employees might not want to give that, but that's certainly worth trying for. And cutting off access to the employees' systems particularly if it's a contentious type termination and the employee's not sure if they're getting the flick or not. Doing it by surprise, getting them into a room, it's at that time when you remove the risk of them going and trying to burn their bridges on their way out the door by controlling that process.
Yeah, interesting one on the passwords and PIN codes. A lot of times we get asked from a forensic tech perspective. So I've got an iPhone 12, you know, it's locked, but surely you can get into it. And the answer, in many cases for the newer model phones, encryption is incredibly tough. So the answer in short is no, we can't. So whilst it can be reset, and it's worth noting that sometimes the employee can reset it remotely. So you take the phone off them and it's just sitting there turned on. They go out, log into their account from another phone, and they can automatically or remotely wipe the device. So you need to be mindful of that and get some advice around that. Normally we would tell you to put in airplane mode and remove the SIM. But also with passwords, you know, you can require them to provide that. And they go, I don't remember what my password is, you know, prove otherwise. But if they're sitting there in the interview and you hold it up to their face, it'll unlock. So, you know, you can access that and then change the password. Get advice before you do that. But so there is some ways around that if you proactively take those measures, or, you know, it might be fingerprint or whatever it is, so they can unlock it and then you can change the password to something that you know and go from there. So there are some ways around that if the employee's being obstructionist. Just saying, no, I don't remember the password. The court's not going to enforce that because they're being truthful. They don't know the password. Maybe they're not being truthful, but either way, you've got to argue. But, you know, now the prevalence of facial recognition, particularly on phones, makes it much, much easier because all they do is look at it and away you go.
That said, I have previously succeeded getting an order from a court to an ex-employee to provide access to a bunch of devices that had been given to them by the court, by the company, which included, you know, by logical extension, the actual passwords to the devices themselves. So you can get it, but it does cause a lot of problems down the track if you have to go via a court to get access. Preserving data. Now, if they fall into the risk categories, one of the more serious risk categories, and they've got a company issued computer, we would always recommend quarantining that device. If that means just locking it in a cupboard, then that's probably enough until it can be collected by a forensic IT specialist. Now, explain why that's important a bit more, but quarantining should happen prior to anyone examining the device internally or being repurposed. So remember, we're talking about high-risk employees, not necessarily everyone, but somebody that you've got a concern about. And the reason for this is that people who don't actually know what they're doing can cause, can tarnish the evidence of what's on the device later on down the track by being a bit ham-fisted in the way that they look through it. And it's very common for the IT team to take back a device that's been handed in, look at it, go through the normal protocols of removing someone's user profile from the device, making a record somewhere, locking it in a cupboard or repurposing it for somebody else to use. And that process can remove very important data.
Yeah, just turning on a computer will change the evidence. But you've got to remember, to a computer, a user ID and a password is the user. So Stan's user ID and password, and I leave the organization, and Dominic, as the IT guy, comes in and he knows, because he's the IT guy, he knows Stan's user ID and password, so he logs in as me. The computer says, this is Stan. And then he goes and searches my email or whatever it is he's looking for. But to the computer, that's Stan doing the search. It doesn't see the person behind the keyboard. So when it comes to an evidentiary perspective from a forensic and evidence one, we've got to then be able to differentiate what Stan did versus what Dominic did as Stan, as the user. So then you've got to explain to the court why there's, you know, after the point where the user's device was quarantined, then there's activity on their account afterwards, and did the user do that or did Dominic do that? And if there's a doubt that somebody else may have done something. So just because they're looking for the evidence, that's the way it'll normally go. And it's not, it's purely because IT people and forensic IT people have a different focus. So it's a critical difference in terms of the explanation. And most of the time when it comes to it, IT people, when you tell them that we're talking about giving evidence in court about what happened, then the IT people will back away carefully, and the forensic people are left standing at the front going, oh, okay, we'll deal with this. So it's really important to understand the difference.
Also talk here about preserving a full copy of the mailbox. I've had problems in the past where companies preserve a copy of the inbox or the sent box. Very rarely do they take a copy of the calendar and calendar notes, but yet I can recall one case where the data theft occurred by attaching sensitive documents to the calendar notes of calendar invites that had been sent out, and it's just not the sort of place you'd look for it. But we found it there, and it was that evidence that we were able to rely on to get an order that the person deliver up all of their computers to us. Without that preserved data, we would never have known that it had been taken. So just saving a copy and preserving a complete copy of the mailbox and everything is a very important step. And as Stan mentioned, Apple devices in particular can be factory reset remotely. That happened to a client of mine where they were, during the exit interview, they'd handed the phone back, and while they were just having a chat, the phone was wiped in front of them. Remotely, the guy did it from the car park. Benefits of using external forensic IT specialists. Now, in court, evidence wins. That's as simple as it is. You can't get around it. It is pointless to conduct an investigation if the evidence you're gathering is unreliable or inadmissible in court, or if the investigator is not qualified to give expert evidence. It's very simple. People who are unqualified, don't have the correct tools to do the job, shouldn't be allowed anywhere near the device, even if they mean well, even if they're the business owner. They might be the best person to advise or to provide some guidance and instruction to an expert, but they're not necessarily the person who has the tools to actually do the job. It's important to think of a device as a potential crime scene.
Definitely. So, like any crime scene you can imagine, you don't let anybody wander into a murder site or whatever and kind of have a look at things. And you know, there's a very methodical process that has to happen so that at the other end, anything you provide is valid as evidence in court, and that you can provide testimony that supports that. Quite often, if it's been trumped in by somebody well-meaning, but somebody goes in and starts looking around, and often it is the business owner, then the unintended consequence of that is that they can actually destroy evidence. So some of the evidence might be available in temporary files, for example, or cache or something like that, and just turning the computer on and doing the searches can destroy and overwrite some of that evidence, which is volatile evidence in RAM is another example of that. When we talk about a digital crime scene, and this just gives you a quick feel, so most people are unaware of the digital footprint that they leave when you use a computer or a phone on a day-to-day basis. So really, we're always trying to answer these three questions. So who created the data? And it's the user, Stan, but is that Stan on the keyboard? Just because they know my user ID and password, that doesn't mean it was me. So part of the investigation needs to demonstrate to a court, to a level that of proof that's required by the court, that Stan was the person who did that activity. So who was it? Who had access to it? And that can be part of it. So if someone logged in, do they have access to the data or not? And also, who is the user? Was it Stan or was it somebody else? In addition to that, where do we look? So unallocated space is an example. If you go to, on your own computer, if you go to my computer and you go to your C drive and it might say it's half full. Well, unallocated space is the half that your computer says is empty, but it's not really empty. There's all sorts of data there. So when you lose your photos or whatever it is, and you go to the computer shop and say, oh, I need I've lost all my photos, I've wiped my phone, whatever, and they say, yeah, we can recover it. Well, that's unallocated space in general that they're looking at because other stuff's been overwritten. So when files are deleted, it's often, if you think about a book, a computer drive is a book with an index that tells you where everything is, what chapter is where. If you rip the index out of the book, you can't find anything because the index is gone. And that's really like deleting a file. All you're doing is ripping the index out. The book's still there. All the chapters are still there. If you sat down and reread the entire book and rewrote the index as you went, suddenly you've got the whole, you could put your handwritten index back in and there's your whole book. That's exactly what data recovery is. It just rewrites the index and suddenly there's all your photos back or documents or whatever it is. That's unallocated space. There's a whole bunch of other swap files, and time and date is an obvious one. Things like most recently used, you'd see when you use Microsoft Word or Excel, when you go file save and you save your file, then when you open Excel next time, it'll say recently opened files or recently saved files, and it gives you a list. Now, you didn't create that list. The computer does it for you because it's trying to help you in, here's stuff you're working on recently. Do you want to go back to that? So the computer is doing that automatically, but that provides evidence not only of what you opened recently, but where that file was stored. Even if it's on an external drive that person's since taken with them to a competitor, the file on your computer will still say that secret document of critical information was stored on an E drive. Even though the E drive's not there, I can still tell you that file was saved on that E drive. So emails, device logs, profile information, there's a whole raft of footprint information that can be gathered from a computer if it's collected and preserved, quarantined, as Dominic mentioned, properly in the first place, then all this is available to you. If it's not, then you potentially lose a large swath of it.
Yeah, and some of this is also a form of workplace surveillance, which is going on, and companies don't have any way to stop it. It's just there happening, and every time the user uses it. So particularly most recently used lists, that's very much very personalized what they were looking at on the day that they left.
Yeah.
Common pitfalls. This is just something that I see quite a lot of. Poorly worded contracts, usually as a result of employers preparing their own contracts without seeking legal advice, or just rehashing the same template over and over and over again without really getting it fixed up. Failing to keep signed copies of contracts, providing staff with access to information without monitoring that access, and maintaining controls over how it can be copied or sent. As Stan mentioned, also not restricting access when a person moves on, so that the idea that they only need to have access to what they need and nothing else. Not maintaining a workplace surveillance policy. This is a very common question when a client comes in and says they've got a problem and they show me this evidence and I ask them for their workplace surveillance policy and they don't have one. Well, what are we going to do about it? Because you can't just go and introduce one today because this evidence you've got is useless. Failing to act quickly once they become aware of a potential breach. This is also, again, an important one. You can't sit on your hands. If you want to run off to court to get an urgent injunction, you need to be able to show the court that you've acted without delay, or they will just assume that you didn't care and will likely dismiss your case if you wait too long. I've had a matter dismissed once when the employer had waited 8 days after learning of the risk and acting. So that's just to put it in some perspective. And compromising the integrity of key evidence by attempting to examine it themselves without realizing what the dangers are. So just move on. Just to finish up, just wanted to talk about a couple of case examples. This is an example of multiple people, including a key person and a disgruntled employee who were 2 of 14 employees who set up to start a competitive business in competition. One of the things that they did, which was quite damaging early on while they were preparing to move on, was because they had too much access to everything, they went in and destroyed copies of all of the contracts of employment of all of the staff who were going. They copied all of the sensitive data that they needed, and then when they left, by design, they ensured that their devices could be wiped. They used Apple laptops, so they were factory reset literally on the way out the door. So the company first became concerned when they saw a LinkedIn post and said, hang on a second, this exclusive distributor of ours is now distributing products through them. What's going on? All the staff suddenly left, and it would all happen very quickly, but they didn't know what to do. So I was instructed to investigate it. We found that they had no evidence. We could not find a single trace of evidence from the company that anything had gone wrong, except the obvious was that they were trading in competition. Now, there was a number of failures in their processes that went on, and the upshot of it was it cost them a lot of money through a reverse engineering process with subpoenas and multiple court processes to actually recover it all. So we were ultimately successful, and my client, as a note here, is still trading nationally. The competing business is not, if you call that a measure of success. But the amount of work and cost involved made it a very difficult case to run. Another one, just on confidential information, this was a defence contractor. Again, their access to classified information is governed by very strict contracts with the Commonwealth. And one of those requirements was that the sensitive data had to be stored in a particular way on a particular type of storage device. Stan could probably describe that in more detail than I could. But second in charge started a competing business. There weren't very good security controls in place. It was just on one server with a partition. So one side was basically the company's main server. The other side was the defense drive. Employee sticks a USB stick into the server, copies wholesale and runs off. The employer discovered the competing business long before he discovered the data theft. But because of the nature of what was stolen, because of the sensitive nature of it, and my client's obligations to the Commonwealth to take very proactive steps to protect its data in the event of a breach, we were required to ultimately get Anton pillar orders, which search orders. We had to go out to the house, seize his devices, have them forensically examined, extract all the sensitive material from it. And this was an employee who, despite his best intentions, never had any chance of competing with my client. He was simply very, I don't know how to say, ambitious. Now, Stan's made just a little graph here of just what actual forensic examination can look like.
Yeah, so, and this is, don't worry about the technicalities of this. It's more just a snapshot of 3 different sources of evidence. So this is kind of what it looks like to us, but this gives us a very clear story. So what I was saying before about when IT people go in and start looking around, I don't necessarily know what they're looking for and they can trample that evidence. But in this particular, this was an IP theft. Somebody took confidential information and went to a competitor. So 3 different, so the USB devices, and again, don't be too concerned about the technicalities of it, but you can see here there was a WD or Western Digital 5 GB drive. There's a serial number, so that identifies the specific portable drive that, or the unique serial number of the specific portable drive that the person used. And you can see here they connected on a particular time and date. It was connected and referenced as E drive. So in itself, that means nothing other than that they connected a Samsung and a Western Digital 5 gig drive to the computer. So without these 2, so what? On a particular date and time, they had a USB device. Now, in this particular case, that USB device and the employee had long gone. So we were only looking at the computer that was left behind. When we took that information and then looked at the internet history, so we could see that the employee on a particular date and time had gone to the intranet, so the iDrive, and they'd looked at a document called, so the apps, don't worry about the percentages, but commercially sensitive folder, pricing information for current tenders.doc, and also had looked at an intranet site for engineering designs and downloaded that file. So again, on its own, this just means that they went to the intranet quite proper in the terms of their job and downloaded the file, no issue at all. Thirdly, the link files, which most people know a link file is a shortcut. So you'll know that on your Windows desktop, it'll say shortcuts or whatever. Again, created as part of the normal activity. And in this particular case, we saw a CapEx variation and the R&D, so engineering designs document, .lnk, so it was a shortcut file, time and date, and it references it on the E drive in a folder called files. Within that folder, there was another folder called hot, super secret, and then there's the file. So whilst the USB device had long gone, as I mentioned, it was some 6 months prior when we did this, I could put these 3 bits of evidence together, which individually mean nothing, but together they tell me that at a particular time and date, the employee connected a Western Digital device with this particular serial number to the computer, accessed the intranet, downloaded the research and the R&D designs file, copied it to the USB, and off they went. So that's enough for the court. So we can then give that back to Dominic. He goes to the court and says, and I can give an affidavit or testimony to that effect to say that this user at this time and date copied that file to a drive we no longer have that drive because it's not on the asset register.
Yeah, and it's that type of evidence that you need to get an order against a person to deliver up a device. They will not ever give you an order to return the grey USB stick. They will, however, give you an order to return product X, serial number Y. It needs to be precise, and without that level of evidence, your investigation could be, as I said before, worthless.
Yep.
Employee fraud, just as another quick example, this was an accumulator. He was caught doing 2 instances of fraud, and it took a lot of work to investigate back, but he was the trusted employee who did everything, had control over every system. He did social engineering, like Stan was describing, with getting access to other people's passwords by just saying, oh, look, I'll do that for you, just log in, let me print that. And it slowly accumulated. He actually had a copy of every single employee's inbox in his inbox, so he could intercept mail that was going in and out. He knew their personal banking passwords. I found that in a spreadsheet, unfortunately. His scam was a payroll scam. Most of the problems that this company faced were probably preventable. I'd say that they were self-inflicted to some extent, and it was because of trust. They just trusted him too much, and over time, he developed a gambling problem. He had a difficult relationship. He had a number of other things in his life, and for whatever reason, he just fell into the habit of just stealing a bit of money every payroll period. And he just had it processed, and it was automated. Even one of the big 4 accounting firms failed to detect it in 10 years of audits. Never noticed, because he was very clever in the way he had hidden it, and he used his position to engineer the environment to suit the fraud. Couple of issues that the company also had was that they relied too heavily on paper archives. They had databases that could only be read on computers that were running XP. I'm talking about a case that I was running 2 years ago. They needed very ancient systems just to even be able to read it. We were getting some of the payroll evidence on floppy disk that they still had. We had to find IT teams that had access to old computers that could simply read the software. It was a lot of work getting it back, but that original $10,000 fraud that we detected turned into $1.92 million over 15 years. Again, that trust issue came into play, and over time, these people like family, it did cause quite a lot of devastation within the business. And I know that there were a couple of people left, including his junior, who had the unfortunate job of catching him the first time around. By luck, it was, and she was quite traumatized because he'd been her boss for several years and trained her, and that betrayal was just too much. I also note this: companies also like to think that police actually care about white-collar crime. They don't, unfortunately. They want to see these types of cases wrapped up in a bow with a ribbon, and a with compliments slip. And the best way to do that is to get someone like Stan's team to do the work and getting the evidence and prepare the statements and hand it to the police in a gift wrap package, because otherwise it'll go to the bottom of their to-do list.
As an ex-policeman, they're hugely under-resourced, and they don't have the capability. And then you can imagine somebody investigating fraud says, oh, I need the IT expert. The police do have them, but they'll prioritise, murders and child-related crimes and other things. So fraud gets kind of pushed to the bottom of the list, and they get so much of those other things that it's constantly pushed to the bottom of the list. So it's not unusual for it to take 12 months, 2 years for them to get around to doing that, whereas we might turn the same thing around in a week. So they're just not geared for it. So if you can put a big bow around it, then they might likely to take some action. And often we kind of reach out to someone we know to say, here's one. It's got a bow on it. It's all done. All the statements are there. The evidence is there. We're ready to give testimony. All you got to do is go and pinch the baddie, maybe interview them. Then they'll take notice and pick it up.
A note here, just on the opposite end of the spectrum. This is probably one of the easiest cases I ever ran. This was a restraint of trade and confidential information case, a multinational waterproofing company. Now, we'd been acting for them for many years, and so they did have policies and contracts that we'd drafted that they'd been able to amend and tweak. They had actually listened to our advice on actually having good systems in place, and they followed through with it, which is one of the biggest parts of the battle, actually getting them to do it. And when an employee, a senior salesperson, gave notice, they just clicked into gear and put their monitoring tools on just to see what he was doing. And they picked up a few things. Some suspicious activity. One was a big data spike on him attempting to upload some sensitive material off-site. They went and got some advice. We had a chat to them, talked them through the process, and we found a couple of other things he'd been doing, a couple of messages on his phone. He was trying to set up a competing business. He reached out to a couple of customers about getting shares in his business, and we sent him a letter and said, look, we know you've been engaged in this activity. Don't do it. We expect you to hand back all of our data and offer the opportunity to give some undertakings to comply. And he refused. So we had everything we needed straight away. We had the evidence from the IT systems, we had the policies, we had the signed contracts. We just put it together in a very simple application to the court. And this one took us 5 days from filing to obtaining final orders from a judge. It was a very cheap, quick process, and all because the company had good systems in place. I'd like to say it was because of us, but it was a really simple case because of the steps the company took. Anyone have any questions?
We've had a question come in from our online audience. This may have been covered already, but just for completion, would you please clarify how internal surveillance can be achieved without the employee claiming invasion of privacy?
Okay, so you can't stop an employee claiming that their privacy has been invaded. That's the first thing to remember. But there's invasion of privacy, and then there's a breach of the Privacy Act. They're not the same thing. So I mentioned before, the employee exemption under the Privacy Act protects a company from making use of or dealing with employee personal information so long as it is in connection with the job that they're doing, what they're employed to perform. So that's one thing. If the employee is doing their job, they turn up to work, you can track what they're doing at work, that's fine. So an example of that might be tracking used in a vehicle. If you issue a company issued vehicle, you put tracking in it, you can track them during work hours, so long as you're not trying to use the tracking tools and surveillance systems outside of work hours. Another misconception I find employees have is that they believe that what they're doing at work is theirs. So using a company-owned piece of equipment to work on company-owned documents is not actually their information at all. So the surveillance that goes on is working out when and how they were there, such as did they turn up to work, did they sit at this desk. That might be personal information relating to the employee, but the work that they're actually doing, what they're looking at on business system tools, is actually the company's information. It's not the employees. So that's where I find employees tend to get a bit concerned. I won't go into issues such as biological information, drug testing, and the like. That's not really relevant to what we have to deal with.
No, but what about somebody who there might be, say, a fair use policy on their computer, but they at lunchtime they access their internet banking and on a work computer in the office. Yeah. How would they go with that?
Well, that is an interesting one. I've had in cases before where an employee had been permitted to install their private email account on a company issued phone. And when they left, they handed the phone back. And the question was, does the emails that were stored on the phone, do they belong to the company now, or are they the property of the employee? And I have this on advice from senior counsel who said, think of an analogy of a filing cabinet. If a phone just is a repository of data, in the olden days, an employee might walk out of the office and leave their filing cabinet behind. The company gave it to them. What documents would be kept in that filing cabinet? If the employee has walked off with them, they've effectively abandoned them. So unless there is something that is genuinely sensitive, such as their birth certificate or their passport, it may well be that the information that's stored in there is now the company's, because it's kept in a company stored environment. There are examples where it might be appropriate, particularly under a fair use policy, for the employer to have a mechanism for returning private information such as photographs from a phone, but that should be done under the policy and it should be dealt with up front and not left to chance.
Yeah, so it still comes back to the policy and how you communicate that.
Yeah, but
proactively.
But as far as managing that, trying to avoid the issue of privacy breach, companies can rely on the employee exemption within limits.
No others?
No others?
Okay. All right. Okay. Well, thank you very much, and to those online, thanks for joining. Thanks, Dominic. We appreciate you coming in. If other questions do come up or subsequent to this, then by all means you can get in touch with Dominic, myself, send them through. Let us know. Our details will be published in relation to it anyway, so you can access them there and just give us a shout. We're more than happy to answer those questions. Okay, thank you very much. To those online, we say goodbye, good evening. To those that are here, still hang out outside and have a drink if need be, and by all means, if you need to head off, then you can do so. Thank you very much. Good evening.
Thank you, everyone.
Thank you.